And let me just tell you what's going to happen in prison. It would be nice if you go to prison, everybody leaves you alone. You're just doing your time, but people are not going to be leaving you alone. You're young, you know, and I'm telling you truth. You're going to be sold for a pack of cigarettes or some extra dessert.
From the moment Judge Boyd opens this hearing, the tone is crystal clear. She isn't here to sugarcoat anything. This is a second-degree felony possession case in the state of Texas, and Isaac Chavez, just 20 years old, is facing a legal crossroads that could define his future. The judge immediately warns him about the harsh realities of prison life, a bold, unfiltered move designed to snap the defendant into reality. In Texas, possession of 4 to 400 grams of a controlled substance carries 2 to 20 years in prison and up to a $10,000 fine. But instead of jumping straight to sentencing, Judge Boyd gives Isaac a chilling picture of what happens if he continues down this path. It's a tactic often used in court to push young defendants toward rehabilitation. Would you agree with this no-nonsense approach, or do you think judges should stay more neutral at this stage? Let us know in the comments.
Is calling.
That's what happens at
2024 CR 1943, State of Texas versus Isaac Chavez. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Doug Campbell for Mr. Chavez.
All right. Are you Mr. Chavez?
Yes, ma'am.
All right. Counsel, have you received all the discovery and did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Chavez, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney?
Yes,
Did
ma'am.
you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 2, 4 grams to 400 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Here's where Judge Boyd lays out the deal on the table: deferred adjudication. In simple terms, it's a second chance without a conviction if Isaac follows every rule set by the court. But it's not a free pass. If he slips up, he faces the maximum penalty, up to 20 years behind bars. Deferred adjudication is a powerful tool in Texas courts, but here's the catch: it's also a legal tightrope. Miss a single drug test, skip a counseling session, or violate probation, and the original sentence comes roaring back. This is where cases like Isaac's turn into make-or-break stories. Think about it. Would you be able to keep up with strict court conditions, knowing one wrong move sends you to prison? Drop your thoughts below.
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand?
Yes, ma'am.
According to the plea, there's a $500 fine. State recommends deferred adjudication in the DOEP course. Did you understand that to be the plea?
Yes, ma'am.
Showing you outside the agreement, the state is requesting that your deferred adjudication be for a term of 3 years. There be a TAP evaluation and 120 hours community service restitution. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Isaac chooses no contest, meaning he isn't fighting the charges but isn't outright admitting guilt either. It's a strategic choice in cases like this, because it lets him accept the terms of deferred adjudication without locking himself into a full conviction yet. But here's the legal twist. Viewers need to understand a no contest plea carries almost the same weight as a guilty plea when it comes to sentencing. Judge Boyd can still impose penalties, and Isaac's record will still reflect the deferred adjudication arrangement. From a legal analyst perspective, this move is common in Texas felony drug cases. It keeps the door open for rehabilitation while avoiding the stigma of a full conviction. But it also means the spotlight is now fully on Isaac's behavior during probation. One wrong move and the safety net disappears.
No contest.
State any evidence.
State offers states exhibit 1 in all evidence.
No objection.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Yes, Judge. Isaac was 18 years old when this incident occurred. He's now 20 years old. I think he's wiser for the events that happened. As the court probably saw, he was shot twice because of this.
This revelation changes the entire emotional tone of the case. Isaac isn't just facing a possession charge. He's a young man who was shot twice during the incident that led to his arrest. While it doesn't excuse the crime, this context humanizes the defendant and could influence sentencing. For the court, these details matter. Judges weigh rehabilitation versus punishment, and Isaac's attorney is clearly framing him as someone who's already faced serious consequences in life. But viewers should remember, judges also prioritize public safety. A shooting tied to a drug case raises red flags, no matter how sympathetic the backstory. Do you think being a victim during the incident should reduce Isaac's punishment, or should the law treat the charges separately?
He was almost at the end of his deferred, or is at the end of his deferred. We're going to hear in just a moment. And he would like to do the TAP evaluation out in the world. He almost, but for this incident, was successful in completing that deferred adjudication.
All right, who is Dynasty Chavez?
That's my cousin.
And how old is she?
Now she's 18, I believe.
And who is Roxanne Chavez?
That's Dynasty's mother, Matea.
And how old is she?
Can't tell you for sure. Maybe early 30s.
Do you have any children?
No, ma'am.
Okay, that's a good thing. How far did you go in school?
I graduated high school.
So what are you doing with your life other than picking up felonies?
As of right now, I was just working at Willie's, a restaurant. I was a server. I was
Okay,
just working where I can. With the felony, it doesn't really allow me to do much.
I'm sorry?
With the felony, it doesn't really allow me to do much. So I just work where I can.
This is one of the harshest long-term consequences of a felony. It follows you everywhere, even if you're not behind bars. Isaac highlights a reality many viewers might not know. Once charged with a felony, employment options shrink dramatically. Judge Boyd seizes this moment to educate him on alternatives, like trade schools and vocational licenses. This isn't just courtroom drama, it's practical life advice delivered in real time. Skilled trades like plumbing, welding, or electrical work can still be accessible to felons if they're transparent about their history and show genuine rehabilitation. For younger viewers watching, this is a key takeaway. Sometimes the bigger battle isn't avoiding jail time, it's rebuilding your life after the charge.
Well, it sounds like you need to try to go to a trade school and do something else. I've had clients before who have been welders and they've had felonies. You just have to let them know up front what your charges are and how you've changed if you have changed. If you haven't changed, of course, nobody's going to take a chance on you. You understand?
Yes, ma'am.
All right. This is what the court will do. There's a $500 fine. That would be probated. There's to be no contact with Dynasty. And that's spelled like the television show, Chavez, or Roxanne Chavez. Who do you live with?
My grandfather,
What's his name?
Alfred Chavez.
I'm sorry.
Alfred Chavez.
All right, and where are your parents?
My mom, she's here in the courtroom with me right now, but I don't know where my dad is.
Okay. Where's your mom? All right. All right, thank you. There's the regular reporting by Zoom or in person. There's to be regular random UAs. 4 years deferred adjudication. 120 hours of community service restitution. That will be deemed completed if you obtain a certificate, get in someone's trade school, It's okay to work at Wendy's. We need people to work at Wendy's, but if that's what you want to do with the
Willie's.
Willie's, all right.
Not fast food, regular restaurant.
All right, thank you. If that's what you want to do, working at Willie's, that's fine. We need people to work at restaurants. But if you want to do something other than your life, then work there, or you have dreams about doing other things, you probably need to go to a trade school, or either you can go to college. Once you complete that, your community service hours will be deemed satisfied, or you can do community service hours. It's completely up to you. I would recommend, though, that you go to a trade school.
This is where Judge Boyd shifts from judge to mentor. She doesn't just hand down a sentence. She's offering a roadmap for Isaac's second chance. Instead of shaming him, she's encouraging practical steps toward financial independence and stability. Why is this important? Because it shows how judges in Texas often balance punishment with rehabilitation. By recommending trade school and tying community service completion to vocational certifications, the court is incentivizing Isaac to improve his future prospects while meeting legal obligations. It's a fascinating legal strategy, turns sentencing into an opportunity for personal growth. And honestly, more courts could benefit from this model.
Become a plumber. Even though that requires a license, you'll just need to tell them about your history and tell them how you improved, and maybe they'll give you your license. You understand?
Yes, ma'am.
There's to be field visits one time per month for 4 months. How long will a tap in custody take? How long out of custody? All right. What drugs have you been using in the past?
In the past, I was using marijuana and Xanax.
All right. So we'll do a referral to felony drug court. That'll happen while he's in custody. Since today is Monday, they'll get to you before the week is out.
This is a pivotal move in the hearing. By referring Isaac to felony drug court, Judge Boyd is steering him toward treatment-based rehabilitation instead of harsh incarceration. Felony drug courts are specialized programs designed to break cycles of addiction. They combine counseling, frequent testing, and judicial oversight to hold defendants accountable while helping them recover. But here's the catch. Success rates depend entirely on compliance. Isaac will have to attend meetings, stay sober, and prove his commitment to change. Miss a step, and the court can revoke the program, sending him straight to prison. Would you consider this a fair balance of justice and second chances?
If he's not accepted into felony drug court, then we can do the TAP evaluation out of custody. And what I'll do then is 60 sober meetings in 60 days. And probation, if you could keep track and make sure that if he's not accepted in felony drug court, they take care of the TAP evaluation. Proof of employment within 30 days. There's to be no employment as a home health care provider with minors. With regards to your grandfather, who all lives with him?
Oh, it's just me, him, and my brother.
All right. And how old is your brother?
He's 18 now.
All right. He is to reside with his grandfather, Alfred Chavez. You're not allowed to leave that residence and reside somewhere else without the court's permission. Do you understand?
Yes, ma'am.
Living restrictions like these are more serious than they sound. By tying Isaac to his grandfather's home, the court is effectively controlling his environment to limit high-risk behavior. This ensures probation officers always know where he is, reducing opportunities for repeat offenses. From a legal standpoint, this also creates a clear paper trail. If Isaac moves without permission, it triggers an automatic motion to revoke probation, a powerful enforcement tool. While this may seem strict, it's designed to protect both Isaac and the community. The court is giving him room to succeed, but keeping tight guardrails in place to prevent future violations.
If you leave that residence and reside somewhere else without the court's permission, a motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
Probation, they want the DOEP course. That course is don't use drugs. It fries your brain. but I'm still gonna give it to you because obviously you need it, okay?
Yes, ma'am.
Probation, is there anything else he needs?
Okay.
All right, is there anything else you need from the court to be successful on this probation? All right, we can go off the record. Here's the thing. In order to be successful on this probation, you know, because you're on probation here. You got to communicate and stay in contact with people. So if there's an issue, let probation know. If you feel as though probation is not addressing it, you can always come back to the court, okay?
Yes, ma'am.
All right, and I'm sorry, back on the record in that cause number, this is run concurrent with 2022 CR 1798. All right, court is calling 2022 CR 1798. Are you proceeding with the motion to revoke?
Yes, Your Honor, he was gonna be turned on Saturday.
All right. Probation, is that your recommendation to terminate him unsatisfactorily? All right, on that probation, then you will be terminated unsatisfactorily. All right.
Yes, ma'am.
4 CR 1943, State of Texas versus Isaac Chavez. Can I have parties announced for the record for the state? Defense?
Doug Campbell for the defense, ready.
And are you Isaac Chavez?
Yes, ma'am.
Are you the same Isaac Chavez who was placed on deferred adjudication in 2024 CR 1943 for the offense of possession of a controlled substance penalty group 2, 4 to 200 grams on April 15, 2024 for a period of 4 years? Is that you?
Yes, ma'am.
State?
On or about the 22nd day of June 2024 in Bear County, Texas, the defendant Isaac Chavez committed the offense of evading arrest or detention of the vehicle in violation of condition number 1. Your
Right.
Honor, do you want me to read all of these and then allow Mr. Chavez to give his plea in
All right.
total or each one individually?
All right. Let me ask Mr. Chavez, with regards to the alleged violations of conditions, there's a violation of condition number 1, 2, 8A, 14C, 14Z, and number 34. Are you pleading true or not true to those allegations?
Not true.
To all of the allegations within the motion?
Yes, Your Honor.
All right. Then the defendant is pleading true to violations 1, 2, 8A, 14C, 14Z, and 34. All right, state, do you have witnesses?
Yes, Your
All right, state, you can call your first witness.
Honor. Equals Angeline Nicholas.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Angeline Nicholas.
All right, state.
Ms. Nicholas, how are you currently employed?
With Bear County Adult Probation.
And what do you do with Bear County Adult Probation?
Supervise, cases,
I'm sorry, you're gonna have to keep your voice up so the court reporter can hear.
sorry. I supervise cases, make sure that they're following the conditions. And
There is a microphone in front of you. If you would put it up using the microphone so the reporter can hear you.
sorry.
Do you supervise a person named Isaac Chavez?
I do.
Now, on June 22nd of 2024,
This is where the cracks start to show. Isaac was ordered to attend 60 AA meetings in 60 days, a standard rehabilitation condition for deferred adjudication in drug cases. Yet his probation officer testifies that he only went to 8 meetings total. Legally, this isn't just a slip-up, it's a direct violation of probation terms. Missing mandatory treatment programs often signals to the court that the defendant isn't taking recovery seriously. But Isaac later claims he actually did attend daily meetings and has proof on his phone, which his attorney fails to present in court. This sets up one of the most suspenseful turning points in the case. Who's telling the truth? The probation officer or Isaac? And if Isaac really had proof, why wasn't it submitted earlier?
did Mr. Chavez make an admission to you regarding his use of alcohol?
On June 24th of 2024, that's when I met with him, but he did admit that it happened on June 22nd, yes.
And when you say it happened, you mean that he consumed alcohol?
Yes.
Now, Mr. Chavez had a number of conditions of his supervision. Among them was to complete one AA meeting per day for 60 days.
Yes.
According to your supervision of Mr. Chavez, how many AA meetings per day did he complete?
It was more so one per week,
And how many in total?
8.
Did Mr. Chavez provide proof of employment or SSI within 30 days of his release?
No,
Has he provided any proof of employment?
no,
Did he register for or attend a drug offender education program?
no verification has been provided.
Now, did you give him a referral for a drug offender education program?
Yes,
Did he provide any documentation that he registered for it or attended?
no.
Any further questions?
Oh, Your Honor.
All right, thank you. State, call your next witness.
He calls Officer Ramos.
Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
I recently got married, so technically my name is Brianna Gonzalez.
I object.
All
Yeah, so.
right.
I know my name still says, I just got married on the 9th, so.
right, congratulations.
Thank you.
All right, state.
How are you currently employed?
I'm employed as a police officer with the Leon Valley Police Department.
On June 22nd, 2024, at approximately 7 a.m., were you dispatched to a particular incident?
I observed a car on Huebner Road, just on the street. The light was green, but the car was parked, or it seemed to be parked. I don't know if the driver's foot was on the brake or if it was in park, but they were stalled in the middle of the road as if they were parked.
And can you briefly describe this vehicle?
The vehicle was a Lexus, 4-door vehicle.
So upon seeing this vehicle, what did you do?
Well, because of the notes in the system, I activated my red and blue lights and I got behind the vehicle to initiate a traffic stop.
Did you get out of the vehicle, out of your vehicle?
I did not get out of my vehicle at that time, no.
And what reaction, if any, did the operator of that Lexus have to you activating your patrol vehicle's emergency overhead lights?
Initially, the operator of that vehicle did nothing. When my partner got out of the car, along with another officer that also pulled up to that traffic stop, they both got out of the car. I was about to get out of the car, but then the vehicle suddenly drove forward and it stopped in the middle of the intersection of Huebner and Bandera Road.
What happened next?
What happened after that is we all got back in our vehicles. We both got closer to the vehicle.
This is straight out of a legal drama. Officer Gonzalez describes finding Isaac's Lexus stalled in the middle of an intersection, foot on the brake, car idling, driver seemingly oblivious. But when officers approach, the vehicle suddenly takes off. From a legal standpoint, this single decision escalates the case massively. Evading police in Texas can upgrade your situation from probationary conditions to automatic revocation and potential prison time. Even if Isaac was intoxicated, and that's debated here, fleeing suggests consciousness of guilt in the eyes of the law. The defense later argues Isaac might have been half asleep and confused, not intentionally running. But courts rarely take that argument at face value when there's video evidence showing evasion. Question for you. If you woke up behind the wheel, saw flashing lights and panicked, would the court believe you?
Then we tried to get out again. I stayed in my car at that point. I didn't get out. And again, the two officers, the one in my vehicle and the other officer, got out to try to make contact with that person again, and that vehicle fled and evaded. So at that point, I told dispatch that I had a vehicle evading arrest.
And at that point, what did you do?
At that point, dispatch asked if I was in pursuit. I said no. So I was still behind the stopping point for that road. So I abided traffic laws and I waited for that light to turn green. That way I could turn
Now, a short while later, did another officer communicate to you that they had detained the vehicle?
It wasn't communicated, it was observed. Because I could see it, it wasn't very far at all.
Okay. Was this vehicle the same vehicle that you earlier observed and that sped away from you?
Yes.
What did you do upon relocating?
Upon relocating to that vehicle?
Yes.
Oh, well, again, my lights were already off. So all I did was, as soon as the light turned green, I turned left onto Bandera Road and I got next to cause my other officer, he had initiated a second traffic stop. He initiated his red and blue lights again on the same vehicle, and I stopped with that officer to try to initiate contact again.
And did you initiate contact with the operator of the vehicle?
Yes, eventually, because, again, the other officer made that second traffic stop technically, and then, we took him into custody at that point.
Did you identify the operator of that vehicle?
Yes,
How did you identify him?
we asked him for his name eventually.
And what did he say?
He said his name was Isaac Chavez. He appeared to be intoxicated.
Did you observe the odor of alcohol emitting from his breath?
Yes,
Did he admit to consuming alcohol?
yes.
How much alcohol did he claim that he had consumed?
Initially, he claimed that he only had one drink, but upon further questioning, I asked him, okay, what did you drink? And he said he drank Modelo and Smirnoff, so it didn't make any sense.
This testimony is devastating for Isaac's defense. Officer Gonzalez paints a vivid picture, a driver with red, glossy eyes, smelling of alcohol, who can't keep his story straight about how much he drank. First one drink, then multiple brands. It's a credibility issue, and judges notice those inconsistencies. But here's the legal nuance viewers should catch. No blood alcohol results are available yet. Isaac initially consented to a blood draw, but later refused, leaving the prosecution without hard data. Without lab-confirmed back, the court cannot conclusively prove intoxication, a huge advantage for the defense. This back and forth shows how probation hearings aren't always black and white. Evidence gaps create openings for the defense, but combined with the flight from police, Isaac's credibility is hanging by a thread.
Did you make any other observations about his physical appearance?
Yes, he
What observations were those?
he appeared to have, urinated on himself.
Is that the only other observation that you made about his physical appearance?
Other than his glossy red eyes, he appeared to have soiled himself and the odor of alcohol on his breath. No, that was about it.
At that point, what did you do?
We formally told him he was under arrest, for evading and DWI. And, we read him his rights, and, from there, we transported him back to our police department.
Thank you. That's the witness.
Officer, would you agree with me that all things in life are a matter of perspective?
Not all things.
How can you be sure that Mr. Chavez saw the lights when you were behind him?
How can I be sure?
Mhm.
I mean, he's not legally blind as far as I know, so they're really hard to miss, so I can't be sure, but any reasonable person, even intoxicated, could have seen those lights.
And he pulled over immediately when the other car stopped him, right?
Well, he was actually already stopped at the red light, so he didn't technically pull over, but he didn't make any further attempts to flee at that point.
Right, and I guess that's my point. If he was just, based on what you're saying, he was asleep in the intersection, right? If he's just waking up, we're not sure he even knew you were there, right?
His eyes were open when I saw him.
Did he recognize you? Can you say that he recognized you?
I could say that he could have recognized a police officer in a police car with their lights on, yes.
Should have, but there's a chance that he didn't, right?
I'm sure, yes, there's a chance.
And during your interactions with Isaac, was he cooperative for the most part?
For the most part, yes.
And he courteous?
For the most part, yes.
and compliant. Once he was stopped, right?
Completely compliant, but the other questions.
And you don't know what his blood alcohol level was because you don't have the labs back yet, do you?
Well, he didn't consent to blood, actually. He initially did and then didn't. But he had a blood draw, so no, I don't know what those results are.
So you can't say with certainty that he was intoxicated.
No, I can't.
Thank you, I'll pass.
Thank you.
Thank you.
State, any other witnesses?
That's all, Your Honor.
I'll call Isaac Chavez.
All right, Isaac Chavez. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Isaac Chavez.
All right, defense.
Thank you. Isaac, we've already identified you as the same guy who's on deferred adjudication for possession case, right?
Yes, sir.
Can you tell the court what was going on, June 22nd of this year?
The day I was
Yeah.
stopped. Oh yes, I was at a friend's house. It was just supposed to be a normal hangout, but he ended up inviting other friends. I do admit that I did have alcohol, but I was peer pressured. I was trying not to at first, but just to fit in, I fed in.
Now, just to be clear, you're 20 years old, right?
19 at the time.
19, okay. And despite all of that, you understand that it's illegal for you to drink alcohol when you're under 21 in the state of Texas, right?
Yes, sir.
And despite all of that, you told your probation officer that you were drinking, right?
Yes, sir.
And did you see the police officer who was behind you in the intersection over in Leon Valley?
Not the person.
If you did, what would have happened?
I would have pulled over immediately.
And that you didn't try to run off when the second officer stopped you, right?
No.
I'm gonna ask you a question. I told you I needed you to think about this. Why do you think the court should continue you on deferred adjudication?
Truthfully, it's just I do acknowledge that I made a mistake. I acknowledge that I was irresponsible. But truthfully, for the past 3 years, I've been completely sober. I've been working honest jobs, helping with my family, my grandfather. Honestly, I was on the straight road. I was doing everything right.
This is Isaac's moment to reclaim control of the narrative, and he seizes it. He admits to drinking but insists he's been sober for 3 years, works honest jobs and attended every single AA meeting. He even claims he emailed the confirmations to his probation officer. Here's where the legal frustration peaks. Proof exists, but no one has it in court. The judge pauses proceedings, giving the defense a chance to verify Isaac's claim. If true, this could undermine one of the biggest violations alleged against him. This moment highlights an important lesson for anyone facing probation. Documentation is everything. If you don't bring hard proof to court, even good behavior can look like non-compliance.
I don't believe.
Let's focus on some of the other violations that they've alleged. You've already told the judge that you admitted to drinking, that you did drink. Why didn't you ever provide any proof of where you were living to your probation officer?
I didn't necessarily know how. I told her where I lived and I had my ID. I didn't really know what more proof was needed.
And the 8603 Cape Valley address is on your ID?
Yes.
And they looked at that every time you went in, right?
Yes.
So you felt like you complied there.
Yes.
There's another allegation that you failed to go to Alcoholics Anonymous every day for 60 days. Did you understand that that was one of the requirements of your community supervision?
I did.
Why didn't you go every day?
I did actually go every day. I have the proof in my cell phone. I have the email sent to my probation officer. I have about 56 of them of every day that I went.
So do you take issue with the fact that she only testified that you went once a week?
I do, yes.
What did you learn, if anything, at the Alcoholics Anonymous meetings?
So let me just stop you. Where is the proof of this?
Judge, I don't have it. It's in his cell phone. I can't.
Oh,
I'm not
where's the
gonna-
cell phone? Did anybody look through his cell phone?
I did not, because I asked him to print them.
All right, you all want to step back and state, you can look through his cell phone and see if there's actually documentation that he did it. And I'm sure if he did it and it's proof there, maybe the state will waive the,
Well, it's just one judge. I got other ones I still gotta address.
I know, but step back, let's see if he actually did that. All right.
We got an opportunity to talk about your two options.
Mhm.
And I think my client would like to take the local ISF,
Okay.
if that's an option.
All right, we're back on the record and cause number 2024 CR 1943, State Waive 14C without objection. Court is finding violations of condition number 2, the consumption of alcohol true. 14C, state waived it. 34, the court will find true. 14Z, the court will find true. 8A, the court will find true. Number 1, evading arrest or detention, the court will find true. Number 1, driving while intoxicated, the court will find not true. All right, probation, my understanding in this case, you're not recommending revocation? Oh, I'm sorry, they are recommending revocation. All right. All right, this is what the court is going to do. Court is going to deny the motion, alter and amend conditions to include probation. Since I'm denying the motion, do you recommend local ISF or state ISF? Because it appears we have alcohol issues as well.
This is the courtroom's turning point. Despite multiple violations, Judge Boyd decides not to revoke deferred adjudication. Instead, she imposes stricter conditions. Isaac is sent to state ISF, an intensive sanctions facility focused on rehabilitation. He'll face GPS monitoring for employment-related movement only. He must attend substance abuse treatment and comply with stricter check-ins. From a legal analyst's perspective, this is a balanced ruling. The judge acknowledges Isaac's missteps, but recognizes his potential for rehabilitation. However, it's also a final warning. One more mistake, and the court will almost certainly revoke probation entirely. Would you call this mercy or a calculated second chance?
Judge, so I did speak to defense counsel and I talked about ISF that is just going to address cognitive. However, if you do send him to state ISF, that you could order him to be substance abuse cognitive track.
Mhm.
Obviously, there's differences in the wait time in custody for both facilities. So that is something I think defense was going to address.
Well,
Somehow,
sometimes that's punishment.
fair enough.
All right, so it's going to be state ISF. And there's to be partial GPS for employment only upon release. And I'll ask that GPS fees be waived. Probation, is there anything else?
Judge, is that going to be through the jail?
Yes.
Thank you. I think that'll be it.
All right, all other conditions will remain.
Oh, Judge, I'm sorry. Is that substance abuse cognitive track?
Yes. All right, anything else?
No, Judge.
All right, we can go off the record. You had better start doing better. Otherwise, you're going to prison. And let me just tell you what's going to happen in prison. It would be nice if you go to prison, everybody leaves you alone. You're just doing your time, but people are not going to be leaving you alone. You're young, you know? And I'm telling you truth. You're going to be sold for a pack of cigarettes or some extra dessert. That's what happens at the prison sometime.
Judge Boyd doesn't hold back here, and honestly, she's not supposed to. This is a judge leveraging shock value to drive reality home for a young defendant standing on the edge of self-destruction. By vividly describing the dangers of prison life, she's sending a message: take this second chance seriously, or you won't survive what comes next. It's harsh, yes, but it's also intentional judicial strategy. For viewers, this is one of the most gripping moments of the entire case. It's a rare glimpse into how courts sometimes step beyond procedure to provoke change.
And this persona that you're giving me now, that's not going to help you at the prison. And maybe people will start fighting with you. Maybe sometimes somebody at the prison be like, I don't feel like fighting with him today. They may say, yeah, I feel like fighting with him today. And that's what you're going to be doing. And the fact that you're young and you're doing dumb stuff is not going to help you at the prison. Do you understand?
Yes, ma'am.
All right, good luck.
And just like that, the hearing closes with Isaac still on deferred adjudication, but on the tightest leash imaginable. His next steps are critical. Comply with every condition, attend every meeting and stay clean, or risk losing his freedom entirely. From a broader perspective, this case highlights how Texas courts balance punishment with rehabilitation. Deferred adjudication isn't forgiveness, it's a conditional lifeline. Isaac has been handed that lifeline twice now. What do you think? Should the court have revoked his probation outright, or did Judge Boyd make the right call? If you found this case as shocking and insightful as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe to Trial Truth for more jaw-dropping courtroom breakdowns every week.